is 7 p.m. I will call the meeting to order. Welcome to the Zoning Board of Appeals for the month of January in the year 2023. Before we begin, I would invite all of us to rise and let's say the pledge of allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I will now ask the clerk to call roll.
Peter Freilinger,
Here.
Christine Snow. Here. David Bork,
Here.
Michelle Stevenson. Here. And Kyle Noonan.
Here. Thank you very much. Next order of business, and I think just to go over a quick agenda, we have the approval of the minutes. We have a single appeal, the administrative appeal 2742 by the law offices of David Laurie on behalf of State Manufactured Homes. We will then have zoning board comments and without any other matters being taken up and adjournment. I would ask, therefore, if the members have had a chance to read the minutes from the December meeting. Are there any comments or clarifications or changes required? May I have a motion then to approve the minutes?
So moved.
Thank you, Mr. Bork. And a second?
A second.
Thank you. And we'll do this just by a show of hands. All those in favor? All those opposed? None. They are approved. We have Kyle. You'll have to. I'm sorry. Kyle Noonan. Kyle Noonan is a new alternate to the board. He was sworn in, I guess, this morning. So fresh out of the oven. We have a couple of addresses. So Kyle will be a full member for this hearing. That gives us 5 voting members for tonight's meeting.
Great.
And thank you, by the way, and welcome to the Zoning Board of Appeals.
Thank you. Happy to be here.
Wonderful. With that, we will go right into tonight's business, which is the single appeal number 2742. Before we begin this, I just wanted to clarify on the part of both the appellant and the town, for appeals, there is a process by which when a denial is issued, there's a certain window in which an appeal has to be filed. Was the appeal filed within the window required under the town's law? Thank you. Yeah, thank you very much.
Well, they never actually decided the appeal that we filed with regard to the failure to issue the certificate of occupancy. In fact, I wrote a letter to the attorneys who were involved in this.
Pardon me, Mr. Chair?
Yes, Mr. Bork.
The speaker should be at the podium.
Yes, we would appreciate it. And make sure that you're speaking into the microphone as well, sir. And for those members of both the board and for our council here, this is my first session as chairman of the Zoning Board of Appeals. So if I make similar footfalls, David, thank you very much for reminding me.
Keep you honest. Don't worry.
Thank you. Mr. Laurie, sorry.
As you probably know, if you've got a chance to read any of the submissions, you'll see there was a go-around with regard to the issuance of a building permit or building permits to begin with, after which there was a condition attached to the building permits. Although we never accepted them, it was written in on the building permits. This is part of my speech, actually, so I will get to it then. Let me tell you, with regard to the issue of is there a decision below? There was no decision actually made. If you see my appeal, it's from their failure to issue a decision because, and I wrote a letter on November 15th to Mr. Socher and to Sally Daggett on this issue, and they had failed to make a decision with regard to the certificate of occupancy, which had been applied for at that time. And my letter gives them 5 days in which to respond. And they didn't do that. They still haven't done it a month later. They still haven't made a decision a month later. So when they hadn't made the decision a month later, well, actually, we're still within 30 days of the deadline that I gave them here. We're within the period of time to appeal their failure to do it. That's when we filed this appeal, and then we went to court shortly after that. Well, actually, it was a month before we ended up in court in the end. And the bottom line is that there is no decision as such. I mean, there's a withholding of the permits, and that's what the substance of the appeal is. This is a ministerial act. If you comply with all the ordinance requirements, they're supposed to give you your permit or your certificate of law. That's part of a rule of law we have in this country. They don't get to not make a decision. And we're here in part because they issued no written decision, but we know very well that they don't want to issue it. And that's why we're here. I have copies of this letter, which I'd like to give to you. If there's a question on jurisdiction, I was holding it back, or not intentionally. I neglected to include it in your package originally, but I brought copies of it for you, which I can pass out. I apologize for doing that at the last minute, but it has to do with the jurisdictional issue which you raised, and therefore it's appropriate for me to give it to you now.
Yeah, if you could distribute it to us, that'd be great. And just for both, or for all council present, we'll accept this given the matter that's being discussed right now. We expected all other evidence to be submitted ahead of and you've been very good, Ms. Rory, in so doing. So we would not anticipate accepting other evidence at this hearing. And I just want to let folks know that ahead of time. Yes.
Yes, okay. I need to make a disclosure.
Yep.
Before we go any further.
Okay.
Let's have, once we determine whether they're standing here.
Yeah.
I can then make my disclosure. So I think perhaps standing should be established first before we go any further.
That's what I'd like to do, David. And that's
Go
kind of
ahead.
what we're trying to do here. So
Okay,
once we determine that, then we'll have another pause where we'll describe how we'll hear the appeal at tonight's hearing. So.
But if the gentleman is going to be voting on the jurisdictional issue, he should make his disclosure before that.
Okay. On that advice then, David?
so for the board's consideration, you need to know that, first of all, that I have a business relationship with State Manufactured Homes in that I own a home in the Hillcrest Retirement Community. And I have a land lease arrangement with them in that community. So I'm subject to a lease, and in exchange for the rent on the land, they pay the taxes on the land, and they provide other services and amenities, in the community. State Manufactured Homes also owns Pinecrest, which is what we're talking about tonight, but it's the same company. So I want to disclose that up front. Second of all, prior to moving to Scarborough, I was a resident of South Portland. And as such, at that time, I was a member of their Board of Appeals. And the Corporation Counsel, Sally Daggett, gave advice to that board from time to time, including administrative appeals that came before the board while I was there. Sally also provided training to the board, as Phil Saucier has done with this board. And I've also attended training sessions done by Sally for our Board of Assessment Review, because I'm a member of that committee here too, that board, I should say. Now, I say all this because the board needs to make a decision whether or not I should be recused based on what I'm disclosing here. However, I will point out that if the board decides to recuse me, and of course I would sit in the audience, I would vacate the chair. That would leave just 4 voting members, which provides a situation where the appellant is at a disadvantage. And I just want to point that out, that there are consequences for the appellant. Obviously, the appellant could choose to request a postponement, and the board could honor that request if it so chooses. So what I'm asking for you tonight is for the board to decide whether or not to recuse me.
Mr. Bork, would any of those factors that you described, and they appear at this level as being secondary, not primary potential conflicts, would any of those impair your ability to act as an impartial member of this board in deciding any of the matters before us this evening?
Let me preface my remarks by saying it could impact the perception of the people here and subsequent appeals or lawsuits. However, I do feel qualified to act effectively as a board member on this subject if the board should choose to keep me here and not recuse me.
With that, let me invite my fellow board members to add their thoughts at this point before asking for a motion.
Could we hear from the parties themselves about their position on recusal?
We may. Are there, and when we say the parties here, Mr. Bork has mentioned several parties. The Council for South Portland, the Council for the Town, and the appellant itself, State Manufactured Housing.
South Portland isn't a party, so I think what we're talking about is David Laurie and Phil Saucer.
Gotcha. Well, I want to be. Yeah. With that in mind, the appellant or the appellant's attorney acting on behalf of the appellant, Mr. Saucier and Ms. Daggett, who were mentioned as being potentially sources of conflict. I'd be interested in understanding your views.
Well, let me tell you, earlier today, the town of Scarborough filed a notice of removal with the Superior Court. We were trying to get a hearing on our temporary restraining order, which we had hoped might be mooted by your decision tonight, assuming you found in our favor, and the town acquiesced in it, which are 2 different issues, of course. But we're hopeful that that was going to happen. Now things are going to get very confused as a result of that, because we still would like to see you make a decision tonight, and we'd like to have a full board, more members of the board, if that's possible. I did not hear Mr.
Bork. Mr. Bork.
Mr. Bork. I'll put on my glasses so I can see that far. I did not hear Mr. Bork say that he felt that he could be completely impartial with regard to this matter. If he make that statement, we will accept it and go forward.
I just by matter of clarification, I did hear him say he could be impartial. He was more concerned about appearance than his ability to act impartially. So appreciate that, Mr. Laurie. Mr. Saucier, maybe if you could describe.
I'll give you room.
The town has no objection to Mr. Bork sitting. I will just address briefly, just so it's clear, my role tonight. I am here on behalf of the code enforcement officer, so I'm not obviously assisting the Board of Appeals, and I have not assisted the Board of Appeals in anything related to this particular matter. So I just want to make that clear. Obviously, you have your own counsel tonight. You have seen me before on other matters. But tonight I'm exclusively here for the code officer in the town.
Thank you, Mr.
Thank
Saucier.
you.
And Ms. Daggett?
Good evening. I'm Sally Daggett. I'm the city attorney for South Portland. We're not officially, so the city of South Portland is not officially a party, but we understand have some involvement in the underlying merits of the case tonight. The city of South Portland does not have any objection to Mr. Bork proceeding, and all I can say is I think he learned well from those various training sessions he went from. Thank you.
Thank you very much. With that, I appreciate the comment. I didn't hear any objections from council. So I'd ask any discussion from the board on Mr. Bork. Yes.
In the time that I've known Mr. Bork, I have never seen anything other than Skelly in all the cases we've worked with. I have no problem with him remaining on this case.
Christine?
I would agree with those remarks.
Gotcha.
I'd be curious to hear our council's thoughts on whether the conflict that Mr. Bork has described could possibly taint a decision that the board makes if his vote is determinative.
Well, the law of conflict of interest is very precise, and this is statutory, laid out in the statute. I'm sorry. The law of conflict of interest is very precise, concise, and laid out by statute. What we're talking about, as Mr. Bork said, is the appearance of a conflict, and the case law suggests, and all the good training that these folks have had, recommends that in the event of a possible appearance of a conflict, that disclosure is a remedy for that. Seems like he made a fair disclosure, and then on top of that, the active parties here seem to have no objection. So I think you're on good grounds, and from what I heard about the nature of his involvement, it's tangential. We are a small community. Even though I live in York County, it's all sort of interconnected, and everybody has some connection somehow to other people. But that doesn't mean that every time that something like that comes up, there needs to be a recusal. So I think you're on pretty solid ground to move forward. But I think there should be a vote. Somebody should make a motion to the effect that he can sit as a board member and there's no conflict or appearance of a conflict.
Is that satisfactory?
That satisfies me, and I'm happy to move that Mr. Bork vote on the pending appeal.
Gotcha. Do I have a second for the motion?
Second.
Snow? Any further discussion? We'll call the roll on this one, Doreen, if that's okay.
Kyle Noonan,
Yes.
Peter Freilinger,
Yes.
David Bork.
Well, I can't.
Oh, that's true. Shelley Stevenson.
Yes.
And Christine Snow. Aye.
Then that motion carries. David, thank you for your disclosure and for being upfront about that. But David will participate in the hearing as a full voting member for Appeal 2742. And with that, we'll continue the discussion of standing. Mr. Laurie had made some preliminary remarks. Are there any other comments on that you wish to make, Mr. Laurie? Or I'd like to have the view of the code enforcement officer in the town, if that's okay.
I don't think he heard you.
Gotcha. Mr. Saucier? Okay. Then, Mr. Saucier, if you could provide the opinion of the town with regard to standing, and then we can proceed from there.
Yes, thank you. I guess I don't have much more to add than what David added in terms of the timing of how this laid out, but I do think there's a particular issue for you to think about, and that is what is actually being appealed. And I say that because the building permit had a condition in it, right? And the building permit was not appealed. That's not the subject of this appeal. The subject of the appeal, from what I understand from Mr. Laurie's remarks and his materials, is the withholding of a certificate of occupancy due to that condition. That's a different thing. And I think one of the sort of threshold issues for you to determine is if that building permit condition was not appealed, if that is now sort of the law of the case here. In other words, there was an opportunity to appeal that condition. It was not appealed. To make explicit it's not being appealed tonight. What's being appealed is the certificate of occupancy issue. So that's the only thing I would add to this discussion of timing and standing.
Mr. Saucier, does the code enforcement officer have the authority to deny a certificate of occupancy? So
I do think he does.
To issue an explicit denial, in other words, rather than just simply withhold the CO.
I think he could do either. In other words, at this point, the way certificates of occupancy work is there is no application per se. It's an application for a building permit. And then once the building has been built pursuant to the building permit, the code officer would then inspect and then issue a certificate of occupancy if it complies with all the standards that were within the building permit in that case. And in this case, from what I understand, the way the timing here was there was a request to issue the certificate of occupancy without satisfying the condition in the building permit. And so the code officer did not issue it. So there wasn't technically a denial, there was a decision not to issue it. So in that sense, I guess there was some decision.
Okay.
But I would just point, so that's all I wanted to point out in terms of the condition itself. It's not clear to me that the condition, the building permit was actually appealed. What we're asking, or what you're here in front of Mr. Laurie's asking about is the actual non-issuance of the certificate of occupancy. Thanks.
Let him finish, and I do have some comments.
Go ahead.
I'm sorry. Are you going to have Ms. Daggett go again? Go?
No, this is just between,
Good.
just for clarification for you guys, we brought Ms. Daggett on because of the explicit reference to Ms. Daggett's prior involvement with Mr. Bork. This is now not a matter that requires her engagement for standing on this issue. So we'll look to the attorney for the code enforcement officer and to the attorney for the appellant for views on this.
Okay. Well, what Mr. Socia is suggesting is that you can separate thunder from lightning in a storm. You really can't. And we asked for building permits. They said they weren't going to give us any. Then I talked to Mr. Socia about it, and I said, we absolutely have to have something in order to give to CMP, in order to get CMP to order the transformers that were needed. And he came back after talking to, I hope he talked to somebody besides Mr. Longstaff, but in any case, he came back and he said that the town was going to issue permits conditionally. Then we got a written out thing and saying that he wouldn't do it until South Portland signed off, basically, but it was just that brief. It's in your file. That's the actual permit that got written on. At which point, I said that under the Freedom of Access law, they're required to make specific findings in order to deny a permit. And they made findings, to deny it or to put a condition on a permit. So they made a finding. If you read the finding, it doesn't actually say why they did it, other than there's two lines in the middle of the next to the last paragraph where he basically claims he can do anything he wants because that's what it says. You know, it says that he is unsure, although 2 years ago you approved this whole project and this particular building, and you approved the fact that their sewer was adequate. That was all reviewed back then. In fact, the city certified the capacity of that sewer. They participated in the whole process. And apparently now what they decided to do was to hold these permits and this certificate hostage to get a different deal than the city made in 1981. And to come back to your, maybe I'm straying a little bit here,
Yes.
but okay. But the bottom line is that we did everything we could to comply with the condition. In fact, there are two agreements that were tendered to the city at different points in time, which should have been acceptable. Either of them should have been acceptable to the city. We shouldn't have had to make any further agreements because we already have an agreement with the city.
Mr. Lyon, we're straying into sort of the body of something that will only entail to us if we determine that standing exists. And the standing right now, it relates to what is being appealed.
And the appeal was based on the unreasonable requirement that the city of South Portland sign off on it, not in the abstract, but because they have not done it. We've made reasonable efforts to accommodate them. We overpaid the fees.
Again, we'll get into those matters and determinations of fact once we get past this.
I think I can help you.
I believe, yeah, we'd like to hear from our counsel.
Okay, so I think you can.
And real quick, we haven't made the formal address. This is Jordan Parkinson is representing the Zoning Board of Appeals. It's not acting on behalf of the town. Is acting exclusively on behalf of the Zoning Board, and will be acting as our counsel for the purposes of Appeal 2742. So with that, we would benefit from your input here, Derwood.
It doesn't seem like there's any dispute that the code office is just about to issue the certificate of occupancy. If Mr. Saucer jumped up and said it's in the works and you'll have it tomorrow, we wouldn't be here. So it's pretty clear that if it hasn't been officially denied, it's what they would call in other circles like a deemed denial, and you can proceed on that basis. I at first was a bit concerned that a certificate of occupancy can't be used as an appeal of a certificate of occupancy can't be used as a second shot at the apple, though. For example, if some homeowners neighbors were upset about the building of a house and they didn't appeal the building permit because they thought it was situated in the wrong place, they can't come in and get a second chance to do it on the certificate of occupancy. But in this case, you can see the findings of fact which have been issued by the code officer, which is something you don't always see, in detailed findings of fact, and the condition of approval all sort of talk about the issuance of the certificate of occupancy and doesn't hinge around the building permit. So I think it's not a big leap to say that they have standing to appeal the non-issuance of the certificate of occupancy, because that seems to be the benchmark on that issue rather than the issuance of the building permit.
Got it. So, and again, from the timing of the clock here, which is part of the standing question, it's clear in my mind, and I'd be interested in the thoughts of the board, that the appellant did appeal what Mr. Parkinson described as the deemed denial associated with the certificate of occupancy being not issued, and therefore the question of whether you missed the 30-day window on the building permit on a putative building permit appeal is not at issue here. So are there other thoughts from the board, or what I look for is a motion that there is standing for the appellant to review this, and we can then discuss from there.
I move that the appellant has standing before us.
Do we have a second?
I second that motion.
Kyle, thank you. We'll take the roll again, Doreen.
Kyle Noonan,
Yes.
Peter Freilinger,
Yes.
David Bork,
Yes.
Michelle Stevenson,
Yes.
and Christine Snow. Aye.
Thank you, everyone. That motion passes, and we agree that the appellant has standing to proceed with an appeal of the failure to issue the certificates of occupancy for, or the deemed denial of the COs for the property in question. With that, let me take a quick pause and describe how we'll move forward for the evening, because this is obviously already a complex issue. What I'd like to have is an order as follows. The appellant will be given an opportunity to afford an opportunity to give an argument for the appeal. We will then have the board ask questions of the appellant, and give, after those questions have been gone through, we'll allow the town to ask questions of the appellant as well. At that point, we will close the argument for the appellant, and we'll offer the code enforcement officer in the town an opportunity to present their argument. The board will then ask questions of the code enforcement officer and the town, and we'll allow the appellant, after the board has exhausted their questions, to ask questions as well. We will then hear any other parties that wish to address the board as part of this matter. Upon that, we will give first the appellant an opportunity to summarize, and then the town an opportunity to summarize, and finally a closing argument on the behalf of the appellant. At that point, we will close the public portion of the hearing. Within those timeframes, obviously, we're already at 7:30, so we've embarked on a good discussion of standing. I would ask all folks to remember that this is a volunteer board, and to please be concise with your arguments, concise with your questions, and allow us to move quickly and expeditiously through the hearing tonight so that we're not wasting anybody's time, while at the same time arriving at the correct conclusions of fact and correct findings of fact, and hopefully conclusions of law as we go through our discussion. That being said, I'd ask, are there any witnesses that are being presented by either the appellant or the town that we can swear in at this time? Could you?
Yeah.
So, yeah. So if you could all stand, please, those who are going to be witnesses. And Doreen, could you swear them in?
I've never done that before, but
Would you like me to? I'm happy to do so. Okay. Could you raise your right hand, please? Do you swear to tell the truth, the whole truth, and nothing but the truth in your testimony this evening? Thank you. And the appellant may proceed.
Okay, we've covered the first part of my presentation, fortunately, but unfortunately, it is still fairly long because we have to go back 40 years or more. All right, as I said a moment ago, if you read the findings that were made originally, they don't tell you much, except that you got to get South Portland to confirm. And it's questionable whether that's legal or not, but as it was pointed out, we didn't appeal the condition itself originally. We tried to comply with it, tried several times to comply with it. Gave them, even though legally we shouldn't have had to do that, we already have an agreement with South Portland. The problem is they don't like that agreement. And they've insisted that we sign an agreement which gives up the rights under that prior agreement. Otherwise, the two agreements which are before you, there's one in your package, which is labeled Exhibit B, because at the time we thought maybe the town would let us just go under the joint agreement that the town had with the city of South Portland, to which SMH was not a party. SMH had rights from 1981 on for the city of South Portland to accept sewage. It didn't have to become part of that agreement. That agreement was offered to other businesses in the area, basically, to get the same rights that SMH already had. The bottom line is that the city didn't want that. The city wanted us to surrender all rights. We signed an Exhibit B agreement, and then again, we sent them another agreement, which does everything, but everything they want, but it doesn't. But it preserves our rights under 1981. Everything they should want. Excuse me. There is nothing. I put the only condition, the only thing we've been fighting over for day one, is South Portland's attempt to rewrite the 1981 agreement, or to force us to rewrite the 1981 agreement. The 1981 agreement, which you now have, we submitted it late, but you now have it, says that we get rid of, how to put it, when the DeFossis family purchased the old trailer park, it was a trailer park, and it was a mess. And they'll tell you that when they testify. It was a real mess. And both the town and the city came to the owners and said, we'd like you to clean this up. And they said, okay, what we'd like to do is, we don't want to have a trailer park at all anymore. We want to have a manufactured housing community, because by then HUD had adopted rules for manufactured housing. These are permanent houses on foundations. And they look like normal houses. I hate to, you said you wanted everything pre-filed before, and you weren't going to accept anything else, but I would like you to look at the house we're fighting over. This is the,
Again, Mr. Glowry, no, we won't be accepting that evidence of this hearing. So no, you can describe it if you'd like verbally, but no, we're not going to have additional written materials submitted at this time.
it looks a lot like my brother-in-law's stick-built house, can I say? But anyway, the bottom line is that they wanted to have a manufactured housing community on every house on a foundation, or at least on a pad, I should say, because it's not a dug foundation, but it's a pad, and it's protected under state law against discrimination. And they were put on lots, and they were approved as subdivisions. 2 years ago, this board, many of you weren't members of the board at the time. If you were, you'd remember, this board approved an expansion of the existing trailer, I got me doing it, the mobile home, the manufactured housing subdivision was to be expanded by 31 more homes. And you heard testimony as to the capacity of the South Portland sewage treatment plant to handle that. Even though the agreement, the 1981 agreement, says that they can have up to 200 homes there, because that's what they had before they got rid of the trailer court. They dropped it back to 112 at the time. And now they're ready to put some more in because of the chronic housing need in the area. This is affordable housing, unsubsidized affordable housing. And it looks good. It looks better than what's out there right now, even. The new houses, I tried to show you a picture of it, the new ones, the ones, this one in particular, looks like everybody else's house. Got garages, it's got a garage built in, it's on different levels, and I think it's a mistake for you not to look at it, but that's fine. The bottom line is that South Portland has been unreasonable. First of all, the condition was unreasonable. Maybe we should have appealed it, but we hoped that they would see reason without having to go to court. That didn't work out. The bottom line is that South Portland is not being reasonable. They want only one thing. They want to get rid of the 1981 agreement. And normally you do that by going to court, or you do that by negotiating a change in the agreement. Instead, they've come up with a third extrajudicial way of proceeding. That is to get the town of Scarborough to withhold permits. I'm sorry, I'm running out of, there's some water there. Is that anybody's water?
Go for it, yeah.
Thank you. I definitely should have brought water. They're trying to do something which would be called extortion. It should be called extortion here too. And they're using the town to do that. They're being unreasonable in that condition, it says the town has to confirm there is an agreement and that the fees have been paid. Well, we know we paid the fees because we overpaid the fees. What we don't know is what they want beyond getting rid of the 1981 agreement. And that is not part of that's not part of Scarborough's reason for being. You're supposed to protect the health, safety, and welfare of the people of the town, not use the town's powers to force changes in contractual relations between other parties. The bottom line is that South Portland is being wholly unreasonable, and the code officer has given them carte blanche to be unreasonable. And he won't look at the fact that that all they want is to get rid of the 1981 agreement. We shouldn't have to sign any agreement, but we've tendered two of them to them. They're both in your package. And either one of them is better for the city, would have been better for the city. They've both been rejected and they're not on the table right now. We're standing on our 1981 rights in court because they blew it. They should have accepted one or the other of those agreements, but they didn't. And we're not, since we've had to go to court on it, we might as well stand on our rights. The United States Constitution says that you can't impair the obligations of a contract through the passage of new laws. South Portland didn't have any of these ordinances that Sally Daggett has put in her package with arrows back at the time of 1981. There are some that claim to be back to 1975, but if you go through the amendments, those aren't the provisions that they want, that they're relying on, I should say. I've been through the clerk's records, or the clerk has furnished me with all those records, and there's nothing there. It would be unconstitutional if they were able to impose new ordinance requirements on Pinecrest. But more to the point, Pinecrest isn't within the city. The bottom line is that Pinecrest is not within the city, and the ordinances by their terms, Sally Daggett is absolutely wrong. By their terms, section 22.22-2 says, that's the scope of the chapter. It says it only applies to, you have it there because she submitted it to you. Take a look at 22-1 and 22-2. Those provisions clearly apply only to buildings within the city of South Portland. There is no part of Pinecrest is in South Portland. And no part of the of any of these buildings is subject to these ordinances, which she claims now control rather than the 1981 agreement. And if they did control, it would be unconstitutional. But the bottom line is that we are in Scarborough. Scarborough rules apply, not South Portland rules, regardless of how the Corporation Council chooses to read them. If you look at the South Portland ordinances, they do not apply to this property, which is in Scarborough. It's connected by agreement. It's been connected since the end of World War II, apparently. It was connected to the old trailer park. And when they redid the whole trailer park, turned it into a manufactured housing community, the deal was they wouldn't have been able to do it without this, that they would be able to get rid of their septic the same way as before. And they've been doing that for the last 40 years. There are 112 units, 112 houses in the manufactured housing subdivision already in Pinecrest. And they're disposing of their waste into a system with a single connection to South Portland. And that was true before, and it's going to be true after this 113th unit is connected to the SMH system. It all goes to one place. Nothing has changed. We pay user charges based on volume. So there's no free ride here. There's no free ride. There's no new connection. So why should we pay new connection charges for 31 units or even 1 unit? This is just a ripoff. And the town should be ashamed of the fact that it's enabling South Portland to extrajudicially rewrite a contract. They could go to court to reform that contract or for a determination of what it actually means and how it applies or whatever. But instead, they've just decided to extract through the town concessions or rewriting that contract. That's what it's down to. Whether we're talking about the original condition, imposing the original condition, or we're talking about how they administer that condition. South Portland is never going to agree to any agreement. Sally Daggett's here, and she can testify, but they're not going to agree to any agreement, that's what they've told us, that does not wipe out or supersede, I should say. Supersede is the language they use in their contract that they're insisting on, that it supersede expressly the 1981 agreement. That's what they want. So you have to decide. I know it's complicated. It's only complicated because they're trying to do through the town what the city cannot do directly, not legally, and they can't do it legally indirectly through you either. What they've done is they've involved the town in a legal mess that's going to cost the town tens of thousands of dollars, probably already has, in attorney's fees. As I said, they removed the case to the federal district court. So what you do tonight won't necessarily be easily integrated into what's already pending now in federal court, because we'll have our 80B appeal from your decision, or the town can take an 80B appeal from your decision if they don't like it. Either way, it's going to be a mess in the courts, and it's a mess now. And it's a mess only because they have decided, South Portland has decided that it's going to extract new contract concessions through getting you to withhold those permits, and you have shouldn't say you, the code officer has decided to do that. I don't know how high up in the town this goes, whether the town manager understands this or the town council understands this, and they understand why South Portland is doing what they're doing. It's not a public purpose to make somebody give up their contract rights, and that's what this is all about. They no longer like the deal they struck in 1981. And now, after my clients have relied on it repeatedly, now suddenly they want a different deal.
Mr. Laurie, I feel like you've gone through a fairly detailed and complex argument in good summary. Could we wrap this up and maybe have you offer testimony? You mentioned that the number of people might be offering testimony on behalf of you.
Yes, I was going to introduce
And I don't mean to cut you
Mrs.
off. I just wanna-
DeFossis. No, I was finished pretty much. I was going to turn it over
Gotcha, thank
for
you.
testimony at this point, because what I say is not testimony as such, it's argument. But as to what has transpired in the past, the DeFossis family are the owners of SMH.
Before we do that, let me ask one question of our
Right.
council. Should we give the board a chance to ask Mr. Laurie questions now, or should we hear the testimony first and then have all the appellant kind of questions happen at once, or?
Either way, if anybody's dying to ask a question right now, they probably should go ahead and do it. Maybe after, you heard everything, you can ask a question.
Again, I just don't want to interrupt the.
I had one question for Mr. Laurie, though. So it was news to me that there's a court case pending, and that's a case against the town of Scarborough?
And the city of South Portland.
Okay,
Both.
and that's been removed to the federal court?
Today, as far as I know, yes.
Okay. Is part of that case the issue of whether the certificate of occupancy should be issued, or the what we're calling deemed denial of that? Are you litigating that issue?
Yes.
So shouldn't you have exhausted the administrative remedies here? And if it's up in the Superior Court or in the federal court, shouldn't there be a remand order to this board for it to hear this appeal? I mean,
Well, we had immediate and irreparable harm. We went there for a TRO, filed that along with the complaint was a TRO. And the courts, you know how backed up the courts are these days in civil matters. They hadn't scheduled it yet, and now it's suddenly before the First Circuit. It's not how to put it, there is no reason why you cannot act just because it was
well, there is a
remanded.
reason, and that is that the jurisdiction sort of floats away from the town and goes to the court.
It would if there were an appeal. It would
I
if
thought you
this were.
said you were contesting the non-issuance of the certificate of occupancy in court.
We're contesting, well, we're contesting is the use of the certificate of occupancy being withheld in order to extort contracting. We've got lots of other contract
All right.
issues in there as well.
All right, I think the board should proceed provisionally on this. It is a kind of a complex issue, and I think I'll huddle up with council and discuss it maybe on a break. Okay.
There are many counts to the complaint.
All right.
And that's one of the reliefs we're seeking, both from the court and from you. And in fact, tomorrow, I guess I'm going to have to meet with council. For some reason, in South Portland, Scarborough, I shouldn't say that, Scarborough, after removing the case to the court, and we got an order today already from the judge saying we had to confer by close of business tomorrow on how we want to proceed with regard to this in
Okay.
terms of briefing.
I think I've heard enough for now, but I just wanted to get that issue on the table, whether in essence, the board's jurisdiction is vaporized because of the filing of the court appeal. I think there's somebody who would take that position.
Well, I don't think so. I think this board has the ability to make the TRO unnecessary. You can moot it if we prevail and the town acquiesces in your decision.
All right. I think, Mr. Chair, they should go ahead with the rest of their evidence, and the board should ask whatever questions, unless you have some questions now.
I'd like to give my other
Yeah.
members a chance to ask
Yeah.
questions. One question of council, is there anything that would prevent us from tabling at this meeting, this matter, or?
No, you could table it, and, you know, so because it seems to be an issue about the status of this federal case and what it means to this appeal.
And it sounds like there are immediate and already scheduled requirements of the court in this as well, given what Mr. Laurie just said.
Mhm.
So I want to hold off on that for now, but I want to offer the other members of the board a chance to have questions.
Yeah,
So-
could I just jump in?
Yeah.
I was going to say, do you want to jump in, or David had his hand raised first? So I just wanted
Well,
to be good on process there.
My comment was regarding tabling.
Okay.
It was, to me, it would seem appropriate to table until the federal court process plays out.
Got it. Okay.
Because this is really a moot point.
Okay, got it. Go ahead, John. Sorry.
Can I just ask a question of Mr. Laurie? So just so I understand the court case, if you prevail in the court case, then will you get a decision that the town of Scarborough was supposed to issue a certificate of occupancy?
That would be part of the decision.
So you are seeking the relief, like a declaratory judgment or something, that the town of Scarborough was to issue a certificate of occupancy.
That's part of the relief we're seeking in court. That is correct. On the other hand, we have, how to put it, if you put this off, it would be most unfortunate because that means that South Portland will continue to squeeze my client who has $5 million into this project and cannot sell anything until this thing is decided in one place or another. You have everything before you. There is jurisdiction here. Durwood's raised that issue, but I think there clearly is power. In fact, there's a duty for you to decide the case.
I would like to hear from if the city of South Portland has a position on this. I think that might be helpful.
I think given some of the questions that have come up, that might be appropriate at this time, because I think some or others may be
Okay.
weighing a motion to table. So I would agree, and before we continue with that, and again, without prejudicing your further testimony of your witnesses or the rest, I think just for the benefit of the board's process, we would like to hear from the city of South Portland's council.
I think just on that
Exactly.
issue of
Limited to that issue,
whether we have jurisdiction to even decide this appeal.
Agreed. Yeah.
The town's attorney in that case is also here, Attorney Franco.
Sally Daggett again, and because the lawsuit that was initially filed in Superior Court against the town of Scarborough and the city of South Portland, it's now been removed to federal court, as a damage claim, it triggered insurance coverage. So I am not the city's counsel for purposes of the litigation. So I am not in a position today to say what the effect of the litigation is on this proceeding, because the city's counsel in that litigation is not here tonight. So I'm sorry, I don't have authority to take a position on behalf of the city with regard to that issue.
Franco, who's representing Scarborough on this in court.
As I say, Mr. Franco, I've been informed that you're representing the town of Scarborough in this, so perhaps if you could reflect on the similar point that Kyle raised.
Apologize for the lack of suit. I wasn't expecting to talk tonight. My name is Mark Franco. I am the attorney for the town of Scarborough. I'm a shareholder at Drummond Woodsum. I was only introduced to this case last week, and today I did file a notice of removal of the case to the federal court. There's no declaratory judgment action pending. There are 5 or 6 counts to the complaint, only 2 of which apply to the to the town of Scarborough. They are 2 constitutional claims. They're both 1983 claims. One is a due process claim, and the other one is an impairment of contract claim. It was my intention to remove the case and to file an immediate motion to dismiss the case on several grounds, one of which is the failure to exhaust administrative remedies. So we're going to go around the barn a little bit on this issue, and I'll tell you why I think you should proceed. I find myself agreeing with David Laurie, which is unusual for me. But so what had happened today is we filed the notice of removal. We received an immediate notice from the court to have a meet and confer conference tomorrow to and let the court know how we're going to deal with the scheduling issue with respect to the TRO. So when we removed the Superior Court case, we removed the complaint. We also removed the pending motion for temporary restraining order. So we're going to have to respond to the TRO in federal court. And we're going to also, we're not going to answer the complaint. We're going to file a motion to dismiss the complaint, which means that if it's granted on several grounds, and I'm not going to get into them, I'm not going to get into the different legal theories that I have to defend that. But once the case is dismissed out of the federal court, it'll get remanded back to the state court, which is exactly where this case should always be, because of the fact that there's going to be concurrent proceedings going on. What should happen in this case is that David should not have filed a complaint. He should have proceeded with this repeal. And if he was not satisfied with the result, then filed an 80B, exhausted his administrative remedies from there, and stayed in state court. Instead, he jumped the gun, filed a complaint, a TRO, including constitutional claims, and he's trying to put the cart before the horse. You can't you can't jump this process to where he is. So I think he's trying to have both processes go at the same time. And I think for purposes of efficiency, it makes sense for you to, I will lose one of my defenses, my motion to dismiss on the failure to exhaust, if you decide the case and he files an 80B. But I have other defenses to get the case dismissed on constitutional grounds.
So sorry, what are the two claims against Scarborough?
They're specious, first of all, but one is a due process claim. Somehow, this town of Scarborough has not provided him with due process, or his client with due process. The other is an impairment of contract claim. In other words, what he's saying, as he said in his opening, is that because the town is not issuing the certificate of occupancies, it is somehow impairing the contract, or seeking to influence the contractual rights of the appellant with the city of South Portland. I've never seen the argument made. I've done the research, and it's not going to hold water.
So isn't the due process claim then presumably the same subject matter as this appeal?
You could argue that you could say, well, we haven't seen how he phrased it factually.
Yeah.
Basically, he's saying that the town erred in not issuing the CO, but he's put a constitutional casing over it.
Yeah.
I think there is a certain efficiency, though, of continuing on tonight. And I would like to talk to the attorneys about the possibility of a remand to this board probably the board won't decide tonight because of the hour. And if there was a remand to this board for his decision, then it could go up the ladder again, and we could clean it up that way.
Can I briefly comment on that? We didn't jump the gun. We went to court, and the court can't get its act together. They couldn't even docket the case completely before the holidays. So that's why we're here before the court addressed our temporary restraining order motion. We're losing money every day. Every day.
My recommendation is that you continue provisionally until we clear up these procedural issues. Everybody's here unless you feel that it's sort of a waste of your time to do that, and you'd rather have more time to come back and do it on another night.
Well, my concern, Dorwood, is if we come back on another night, we're going to repeat the process with the appellant, who will go through their case, potentially described differently, pending opinions of the courts. And I'm also concerned the city of South Portland may not be in a position to fully represent its interests tonight, given the triggering of the insurance claim and the change in counsel required by that.
Well, you're certainly in your right to move to table a case until we clear up these procedural issues.
And I'd also say some of these procedural issues seem like they will have some clarity in a matter of days, or certainly a couple of weeks, not a period where we would be lingering past the next meeting. So on that basis, I'd be interested if there is a motion to table.
Can we talk briefly about that? I actually think, because everyone is here, I would be inclined to decide the appeal. I say that because, I mean, if, let's say that we rule against the appellant, I think the appellant would be then hard pressed to say that this decision, that we didn't have jurisdiction, given the representations that he's made tonight. I would expect that the city of South Portland and the town of Scarborough would prevent him from taking that position. What do you think about that?
I mean, the question that keeps going through my mind is, has this jurisdiction of this board sort of left its board? It's almost like it's traveled virtually to the courts now.
Yeah.
If, for example, somebody gets denied a permit for the building inspector, and they file an ADB case the next day and a zoning board case. I've seen that scenario before. The proper advice then is for the Superior Court to remand it to the Superior Court for consideration of its appeal. This is maybe slightly different because the way it's set up as a due process claim and some sort of contracts clause claim, maybe it's a slightly different variety there. I haven't seen this done. I'm sort of with Mark Franco on that. It's very unique how that's phrased. So, I mean, I guess it's really up to you. There's some efficiency of doing it tonight, or as the chairman said, there could be some downsides. So I recommend you just hash it out among yourselves, and either way, you're really not wrong.
Gotcha.
May I speak for a minute?
I prefer not. This is really the board discussing whether it will bring a motion up.
I understand, but everyone's talking about how unique the situation is. And it's
We're
unique.
really talking about the use of our time, Mr. Laurie. So I'd like the board to discuss this among itself. And I think we've gotten input from various council in the right way. So again, I'd ask for the opinion of other members of the board at this point. Yeah.
My big question is if we hear this fully out and we. Oh, I'm sorry, my mic's on.
Yeah, just.
If we, I lost my train of thought a little bit there. If we make a decision tonight and this goes to their case, does it negate anything that we do here? Does that make sense? Like,
So-
are we wasting our time if they still proceed with the courts? Or will there be?
Or David, yeah.
So if you look at what we're here for tonight, is very narrow in its scope. And at the same time, there are a lot of extraneous things going on. So we're basically here to determine whether or not our code enforcement officer, Brian Longstaff, erred in his decision regarding the issuance of a CO. And that's it, nothing else. Because of the fact that so many other things are involved here, I'm inclined to enter a motion to table.
Okay. Thank you for the motion. Do we hear a second? Second, Christine. Discussion? And Kyle, maybe you can start us off.
Yeah, I mean, I'm conflicted about this because I don't want to waste everyone's time, and I do want the appellant to have a chance to, to make their case. But I share your concern, David, that this could that we may not actually have the ability to make this decision. I mean, I think if the characterization, of course, we don't have the complaint in front of us, but the due process claim could have divested us of jurisdiction, I suppose. I mean, it's an argument that the town should have issued a certificate of occupancy, and it hasn't. So that's probably the safest route, is to table it. We have a meeting every month, correct? So we could bring this matter up again next month and hopefully have clarity by then on.
What about us? We've got $5 million sitting.
Miss, this is not the time for a public discussion. We're out of point of order. We do. And this is not the time for public discussion. This is discussion of matter of the board on a motion that's been brought validly to the board. Thank you, Kyle. Anything else?
And just to address that point, Mr. Fossis, I mean, this is something your attorney filed the lawsuit. This is not something.
Mr. Fontes, this is not the time
Sorry.
for discussion. And Kyle, it would be more appropriate to address these comments to me.
Thank you.
Anything else?
No.
I didn't mean to.
No,
cut you off.
that's it. That's
Yeah,
it for me. Thank you.
Very good.
Anyone else? Then I would call for a vote on the motion to table. Doreen, could you call the roll?
Peter Freilinger,
Aye.
David Bork,
Yes.
Michelle Stevenson,
Yes.
Christine Snow,
Aye.
and Kyle Noonan.
Aye.
The motion passes. The item is tabled until the February meeting. Thank you for everyone. I'm sure we'll see all of you next month. Do we have any other business? David?
Yes. Well, are we talking about getting into zoning board comments?
Yes, that's where we're at.
Thank you. Okay. There, just for the benefit of our new member, as well as the other alternate who is not here with us tonight, as well as any other members who may not have attended a training session by the Maine Municipal Association. I would point out that there is one coming up in February. It's a virtual meeting, a Zoom meeting. It's very easy to attend these, and there's no cost because the town will pay for the fee associated with that. So I would encourage you to participate in that. Contact Doreen, she could set it up for you.
Thank you.
And I'd add to that for you, but for everyone, and Dave's mentioned this before, it's great to do a catch up of these every couple of years too, because they do have different presenters, different focuses, et cetera. So if you've done it before and you haven't done it in a while, great opportunity to refresh on that one. Anything else? Any other comments from the board?
Motion to adjourn.
Welcome,
Motion-
Kyle.
May I second it?
Oh, I said welcome, Kyle.
Welcome.
Thank you.
I second it.
Terrific. All those in favor will just go with hands. Meeting is adjourned. Thank you very much, everyone.
Shelley, did you second that? I have